In terms of employee email, the employer has to ensure that the email system does not have risk or harm morale. So you have a policy in place that doesn't make a more risky liability situation or be so constraining that it creates a morale issue. So we have to recognize, first of all, that email lingers, that employees should know that even though you delete an email, it doesn't mean that it's not on a server in a backup system somewhere, that a deletion policy is not an appropriate cure, that anything can be found with appropriate records in a subpoena, right? We want to review emails in connection with a reasonable investigation of possible employee misconduct. So it has to be reasonable to expect if you think someone is engaging in criminal activity or inappropriate behaviors, you can investigate the emails given that. And employers must act on misconduct discovered via monitoring. So if you monitor and if you find there's harassment or illegal activities, if you don't act on it, you are also liable from having an unsafe workplace or a hostile working environment for that matter. So it's important that if you're going to do the investigation, if you're going to do the monitoring, you need to act on it. You need to follow through and properly handle it with a consistently applied policy. Follow through is essential. Having a good solid policy and a consistently applied policy is going to be the thing that's going to save most organizations from their biggest headaches. In terms of GPS tracking, a company-owned vehicle is generally okay per statute to monitor GPS location and having a GPS locator on that. So if you're driving a truck for somebody, for a company, and they put a GPS tracking device on it, they're entitled to monitor that and to determine where you are and whether or not you're where you should be in some circumstances. So if it's your own vehicle, they cannot put a tracker on it, right? That's a violation of your privacy. So that's the intrusion into seclusion, right? If that's the the example of that in terms of common law. State statutes are requiring consent, notification of use, and limiting use for employee-owned vehicles. And again, if you're going to use your employee vehicle, then there's clear guidelines in what it is, and you have to have, a certain a degree of consent and agreement as to what will be monitored and why. Your RFID chip implants. Uh, the state laws currently ban mandatory implants. Doesn't mean people can voluntarily do it, but it's banning mandatory implants. So if we find that people are being chipped inappropriately, then they can protest and they can sue. Hardware and software tracking, again, keywords, keystroke tracking, all sorts of things. You'll be stunned at the level of minutia and level of detail that can be gathered using hardware and software tracking devices. Artificial intelligence is a growing area, and we can't even begin to understand the level at which artificial intelligence can be used and the potential for it to be used. AI is a tremendously growing field. It can collect a tremendous amount of data at a granular level, at an absolute granular level, so that we can get fine-tuned data down to megabytes, and how often you trend towards a particular website or listen to an ad, or how often you scroll on Facebook, etc. I mean, you'd be amazed at what AI can do. Employers or consultants use chatbots as a way of screening applicants, where you would apply for a job and a chatbot would engage with you online and basically ask you questions to pre-screen you, to look at your resume. The problem, of course, that we have is that on the one hand, it may remove some bias, right? Because a bot can only do what it's programmed to do. It doesn't have its own level of reasoning through things. But and it can screen social media very quickly without password authentication. So it can screen your social media through bot usage, and it can know what you've posted, even if you have it password locked down. I know it's kind of scary to think about that. It can do interview analysis. It can look at how well you've you've done through an interview and it's been recorded, and then that interview can be broken down and can be analyzed for certain data. So on the one hand, these bots seem like they are a great idea, but and it seems like it could eliminate bias, but we also have to be careful about the amount of candidates we might lose because the bot is not programmed to read certain things. Um, Honestly, as much as there's bias in human evaluation, there are still good things that human evaluation can see that bots can't see. So there's a fine line between eliminating bias and creating a discriminating situation where someone may not pass through a bot because they don't have a particular keyword in their resume or a keyword in their interview that would let them get the next step. It doesn't mean that they're not capable of doing the job. So we have to figure out how to balance that. They are largely untested from a legal perspective, right? And so again, we're balancing who controls this information, how is it being used, et cetera, et cetera. So we will probably see in the next 10 years a lot of tests, legal tests on whether or not AI is appropriate to use and under what conditions it's appropriate to use. Lastly, this notion of biometrics and body scans and, fingerprint data, eye scanning, hand in face scanning, voice analysis, all of that. The sophistication is wonderful, but it can lead to invasion into private realms that we have to be very careful about. Can we use aggregate data to answer questions? Are we being careful about making sure that we're using things anonymously? We also want to be careful of what we call function creep, where we are engaging in behaviors outside of the scope of what it was originally designed to do. And we might be using it for things that might be considered and construed a violation of privacy or inappropriate to gather that information. So these are all ethical and legal questions that we need to be careful about. And I expect an uptick in legal cases on this over the next decade for sure. So Exhibit 1414 talks about the allowable monitoring, allowing telephone calls. Monitoring is permitted in connection with quality control. Notice to the parties to the call is often required by state law. So you will hear, this phone call will be monitored for feedback for our employee. If the federal law does allow monitored calls by the employer of the employee. If the employer realizes a call is personal, then monitoring must cease immediately. So we cannot hold on to information that is private. So if we allow people to use their phones at work for private calls, right? We can't use that information in any kind of investigation. A private call is a private call, period. Email messages. Under most circumstances, employers can monitor employee emails on work accounts, even in situations where the employer claims it will not. Its right to monitor has been held fairly constant and fairly consistently. However, when the employee's reasonable expectation of privacy is increased through a password protected account, for example, this may impact the court's decision, but it's not determinative. So if you have a password protected situation, and the employer breaks into it, that might be the concern, right? So we have to figure out where that fine line is between whether or not the password protection provides that reasonable expectation of privacy, right? A voicemail message system, although not completely settled, it does appear that as long as employers have a work-related reason to question the content of the voicemail, they can monitor it, but it has to have a just cause for it. It may be difficult for an employer to prove no assumed privacy if the employer said they wouldn't monitor. So if you're saying you don't monitor, then you don't get to monitor, basically. But if you say that you could be monitored, then obviously you want to make sure that that you're monitoring and you use it for the reasons that you're monitoring and that you're not giving mixed messages around that. If you're giving employees a private voicemail access code, then then that's private, right? Internet use. Where the employer has provided the equipment and or the access to the internet, the employer may track, block, or review their internet usage, period. That they are entitled to be able to do that. In terms of developing computer use policies, It's important that the employer recognize that they should develop and communicate very concise written policies and procedures regarding computer guidelines, whether it's internet use, equipment use, etc. No monitoring can be done in highly private areas like bathrooms or changing rooms. Monitoring is limited to the workplace, right? You cannot monitor people at home. Full employee access to any information gathered through monitoring. The employee has to have access to that information that is being monitored. And there should be no perpetual or continuous monitoring ongoing. I mean, we don't want people to feel like everything that they're doing, breathing, living, existing is under continuous monitoring. There can be no secret monitoring of your employees. They have to be given advance notice. Only information relevant to the job should be collected, and monitoring should be result in the attainment of some business interest. So if you're going to monitor, what is the business interest? So you ask yourself, why are we monitoring? And you'll be able to document why we're monitoring and how it impacts the organization's bottom line, period. Terms of BYOD, bring your own device. A lot of employees are using their own personal smartphones, tablets, or laptops for business purposes. And again, this sometimes is easier, particularly if the business is struggling financially, right? It might be easier for employees to provide uh, their own documents. I also will use my own personal computer to do my work for my job. And I can do this, and I use my Dropbox account, and I share files in my Dropbox account so I can share and have access to them anywhere. What it does is it decreases the cost for the company in terms of managing the devices, managing the data, and the IT support that goes around it. But there are practical risks and legal risks, right? We've got liability of company-specific information that's on an insecure, a non-secured computer. We've got issues of cybersecurity. We've got issues of um, the computer being stolen, and other sort of protections that we would want to keep in mind. So the security of the data is at issue. The networks that they're on may not be secure, whereas a company computer might have a more secure connection. Um, and so virtualization um, is a big issue, right? About how do we access virtual data on my work computer, but I can use it on a home computer, right? So I can have some of a VPN that enables me to have a virtual connection to a workplace thing. So I can access something on my work computer, but I don't have to download anything. So there's all sorts of different challenges that we're going to face with respect to bring your own device. So you want to make sure that you've thought through all the security precautions and the technology precautions that you want people to do. Now, smaller businesses, this might make sense, but for larger businesses, this is not worth the risk, in my opinion, personally.